Hi, welcome to my channel. Please like, comment, and subscribe. In an ordinary employment relationship, an injured employee must submit his claims to workers' compensation in order to recover compensation for a workplace injury. However, the Jones Act provides a special right of recovery for seamen injured because of an employer's negligence, and permits a seaman to file a negligence claim directly against its employer. The Lafayette Maritime lawyers at Broussard and David represent injured seamen and can assist you in filing a seaman claim against your employer. Our attorney have a record of success in maritime litigation and will work with you to develop theories of recovery that will fully compensate you for your injury. Under the Jones Act, a seaman is the sole class of workers that can file a negligence claim against an employer. An injured seaman can only file a claim against his employer if the employer improperly maintained his vessel or if the seaman can prove that the employer or a crew member negligence caused his injury. If an injured seaman successfully proves a negligence claim under the Jones Act with the assistance of the maritime attorneys at our Lafayette firm, the injured seaman may recover compensation for maintenance and cure, including lost wages and future wages, medical expenses, pain and suffering, and also mental anguish. If your loved one suffered or were injured on this job as a seaman, you should seek legal advice immediately. An experienced Lafayette Maritime attorney can assist you in understanding your legal rights and filing a seaman claim against your employer. We offer a complimentary consultation to all prospective clients. Every day, seamen face dangerous working conditions that do not surface in the traditional workplace. Because of the very physical nature of work at sea, countless offshore workers sustain injuries each year. Unfortunately, many of these injuries are a direct result of an employer negligence and are entirely preventable in the view of a Lafayette Jones Act lawyer. The Jones Act, together with the Longshore Harbor Workers' Compensation Act, or LHWCA, provide remedies to certain maritime work for injury and also death. Specifically, the LHWCA provides a workers' compensation remedy to employees injured in the course of scope of maritime employment upon navigable waters, while the Jones Act provides injured seamen with a cause of action for employer negligence. Broussard and David has a track record of success in representing injured seamen under the Jones Act. If you or a loved one sustained an injury while working offshore, you should contact an experienced attorney to learn about your legal rights. Based in Lafayette, our Jones Act attorneys are available to help you understand your legal rights and to work to ensure that you are fully compensated for your injury. The Jones Act is a federal statute that applies to offshore workers who are injured at sea. The Jones Act permits an injured seaman to recover for any injury that occurred as a result of his employer's negligent operations on a vessel or use of unseaworthy vessels. To recover under the Jones Act, an injured worker must prove seaman's status. A court determines seaman's status based on the nature of the injured individual's employment, including the characteristic of the vessel and the circumstances surrounding the injury. The person must be a member of the vessel's crew. Land-based employees are not entitled to recover under the Jones Act, but may be entitled to recover under other maritime law statutes. In order for an injured seaman to recover under the Jones Act, he must first prove his seaman's status. Next, the injured seaman must prove that his injury resulted from his employer's negligence or that the vessel's owner or operator kept the vessel in unseaworthy condition. A vessel is unseaworthy if the vessel was not reasonably fit for its intended purpose. Under the Jones Act, an injured seaman can recover maintenance and cure. Maintenance is a small daily allowance intended to provide some compensation for lost wages. Cure compensates an injured seaman for medical treatment and related expenses. Our Lafayette Jones Act attorneys have researched and David over expertise in areas of maritime law and are available to analyze Jones Act claims and discuss your legal rights. An experienced attorney can dramatically increase your ability to recover a favorable award that will fully compensate you and your family for your injuries. The maritime industry consistently ranks among one of the most dangerous industries in the United States. This risk of danger is even greater, however, when U.S. employees take work in foreign waters. U.S. workers are often unaware of the risk of working in the territorial seas of foreign countries when they agree to work overseas. Our Lafayette maritime lawyer can help explain the complexities of your situation. If you suffered an injury at sea in foreign waters, you may have questions about your legal rights. As a U.S. worker, you are still being entitled to relief under federal maritime law. Depending on the facts of your case, you may be protected by the Jones Act, the Longshores and Harbor Workers Compensation Act of General Maritime Law. There are several reasons why offshore work overseas is more dangerous than U.S. Offshore work. First and foremost, many companies send their employees to the United Kingdom or countries in Africa to avoid compliance with stringent regulation in the United States. In 2012, the United Kingdom also offered financial incentives to corporations to increase deep sea drilling in the North Sea. Many companies have taken advantage of these incentives and have sent U.S. an offshore industry that lags far behind in safety than the United States, Africa, the Middle East, and Asia. With less regulation and pressure to increase deep-sea drilling, offshore work in the North Sea typically involves long hours and poor working conditions. In addition, the North Sea is a perilous body of water and workers tend to labor far from the shore. To get workers to and from platforms, North Sea employers typically transport employees by helicopter. However, these helicopters are unreliable and can be delayed by treacherous weather conditions, leaving workers stranded at sea for prolonged periods of time and exacerbating injuries or sickness. Thank you so much for watching. Don't forget to like, comment, and also subscribe.